Hi. Hey, hi, hello. Namaste. Welcome to Telugu NRI Radio webinar on US immigration. Yeah, last week we had a terrible network issues and we suspended middle of the show. Sorry for interrupt, and we're trying to keep improve our program, and we are improving content. So this week we are coming with new updates and very good news for H1s, H4s, and L2s. And yeah, why do you wait? It meant just welcome to Lucas. Hi, Lucas. Welcome to today's show.
Hi, Venkat. Thanks for having me, and thank you for everyone for tuning in this week. I know we had issues last week, so it's great to be back. Sharing information on this platform.
Yeah, thank you. Thank you very much. So, Lucas, we have a very good news. It's more than one good news. And we can discuss the H1 prevailing wages new policies and Biden new policies. And also we can cover the 485, the October 485 AOS, and we can discuss the other things too. So before going to show, so Biden is doing very fantastic job for immigration. We are saying one by one what the Donald Trump implemented a lot of complicated immigration for non-immigrant. So we are saying one by one is resolving. So we will get the more information from Lucas. Yeah, you can share, Lucas. What are those good news and good news?
Well, in regards to H4 and L2 visas, along with a few e-visas, biometrics is now going to be suspended for those visa categories as of May 17th. Now, this is a result of a lawsuit that was filed, and I know a lot of people participated in, that was filed in Washington. And, there's a team of attorneys that have been working on this, and they've been responsible also for the filing of a few other rescissions of other policies. So they've done tremendous work, and they've kind of kept rolling back these policies that the Trump administration has implemented. So it's really great to see things go back to normal. For what most people, if you don't already know, what this would mean is that let's say if you're a principal non-immigrant H1B or L1 visa holder is filing for an extension, then you can go ahead and also, much like in years past, benefit from maybe a premium processing file, where the file would stay together when it goes through the service center, and that would help reduce delays. Obviously, with the biometrics requirement, we were seeing approvals that were taking 7, 8, 9 months, depending on where the person lived. And hopefully this will go back and result in the way things used to be maybe 3 years ago, where we could expect approvals within a week or two after the principal non-immigrants extensions were approved.
Okay. Lucas, is really good news for H4 and L2 biometric. Ultimately, is ended from March 17. So, what is the situation? We know the lot of the application piled of to adjudicated for H4 and L4 biometric. Do you think USCIS will adjudicate all applications, or without any? It means waiting. It means the waiting. What do you think? Can we expect next couple of weeks or next 1 month everyone will get the EADs?
No, unfortunately, that's not going to probably move that quickly. I still don't know all the details of what the agreement is. Now, the agreement is suspension of the policy for 2 years, I believe. And, there's not a formal statement from USCIS or anything else in regards to this. It's just, what was shared from the other attorneys that were handling the case. Obviously, they shared the information not only with the public, but also with AILA. And AILA was also part of this, lawsuit. the American Immigration Lawyers Association. So, I'm not. I don't know all the details. I just know that everything's going to take effect, and the suspension is going to begin May 17th. And I don't know how it's going to impact the other cases. It could be one of two things. It could be, suspension, from that date moving forward for all cases, wherein, everything would go back to just regular processing without a biometrics requirement, or, since now that future cases are being, suspended with the requirement for biometrics, maybe that would speed up the processing if any other pending cases still require biometrics. So we'll see, and hopefully I have more information next week that we can update all the viewers.
Okay. It means what you're saying is already it means applied till May 17th. USCIS should be sent the biometrics, right? You mean to say, or?
So when we filed for H4 extension, let's just use that as an example. The filing fee is $370. Now, in the past couple of years, we had to add the extra $85 to that for biometrics. So, starting also in the 17th, without the biometric requirement being there anymore, the filing fee will go back to $370, and it'll move forward from there. So the question would be is how USCIS is going to handle the backlog. If they're just going to, because let's say, for example, someone filed 6 months ago. Well, they also paid for the biometric fee. Is that something that's going to be returned to them if they decide to not continue with biometrics? Is it something, so I just need to wait to hear more details about what USCIS has agreed to do. But it's great news, and this requirement is suspended for 2 years. And I would imagine there will be some type of agency action before that's up to probably remove that requirement completely.
Okay. But in previous experience with USCIS, is there any chance? We know that USCIS collecting the application fee plus biometric fee, right? Correct. So if USCIS, is there any chance to decide return the $75 or $85 for the biometric? Maybe they reissue the checks and adjudicated the 485 and H4 EAD and L2 EAD. Is there any chance, or maybe what do you think in this scenario?
It depends. What I think is starting on the 17th, we won't be required to go through that process. So we know 100% based upon the information we have in front of us that, let's say if someone has an extension that's coming up, by summer, fall, you would probably want to wait to file that extension until, especially if you have a dependent visa through H4 or L2, you would probably want to wait to file the extension until after the 17th of May. And that way, we guarantee that, we'll have no biometrics requirements. So as far as the pending cases and the backlog and how USCIS is going to address that issue, we'll wait and see what the official comment is after everything's finalized. But, this is just really, I think 2 days ago, it was just really like a late night agreement. And the court case was out in Seattle, Washington. So it's on the Pacific coast. And it really, once everything was agreed to, it was really late at night, and everything kind of took off the next morning. And I haven't heard any actual concrete details about the pending cases yet, but we do know for sure May 17th, the biometrics is no longer required for those categories. Okay.
Maybe whoever decided to extend it last couple of weeks, maybe wait until May 17th, then apply in premium process. So USCIS will adjudicate both applications together, right?
Correct. It should go back to the way things were, where the officer will have both application and petition at the same time. And, in the past, in the good old days of, 3 years ago, we would expect, spouse's application to be approved within the same week, and the card usually followed within the week after that. So hopefully things go back to that, moving forward.
Okay. Yeah, that is very good news for the long waiting for H4 EADs and L1 EADs. So yeah, guys, wait for May 17th and apply the extension with premium process and get EAD as soon as. So if come to the second topic, what are the H1B new policies recently added or changed, or is anything?
As of right now, what policies are you referring to?
New H1B policies, maybe prevailing wages, or maybe Biden is bringing anything new, anything adding, or maybe removing or something.
Well, I think one key change, and this is not so much with H1. This encompasses part of H1, the prevailing wage that can be issued Department of Labor, encompasses H2 visas, H1B1, E3 visa if you're from Australia. So whenever you want to get a prevailing wage issued, there's, with H1Bs, there's so many requirements for just so many LCAs to be filed. The employer has the option to go ahead and, complete that as they see fit, as long as it's within the filing guidelines of what's required. But for like a GC, you have to file the prevailing wage and wait for the response. And right now we're seeing such a long delay. We're at 5.5, 6 months to get back the prevailing wage. So DOL has gone ahead and updated their ETA 9141 form to include additional information. And one of the major changes that we saw was where in the past, some practitioners, attorneys would put, we would have multiple unknown work locations in the future, things like this. And now that's really not allowed or permitted anymore. And, you have to list the actual work sites. This new process is supposed to speed up everything, but we're waiting to see. Now, going back to what you were saying as far as the president, we have to remember he's also come out and said, we want to strengthen the American economy. Donald Trump had the mantra with his executive order, buy American, hire American. Joe Biden is also very much trying to strengthen our local, national economy here, in the sense of, buying American products and things like this. And also very much involved with this is the support of labor unions. So just because he's very much opposite of Donald Trump on some policies, he still might have some policies or decisions that might impact, our non-immigrant workers that are here supporting our economy and assisting. So I think he's been receiving a lot of input from all sides. I think there's been a large push. We had what we call a National Day of Action a couple weeks ago, where all immigration attorneys, contact the representatives for the state. Obviously, with COVID-19 right now, it's all done telephonically. But in the past, a lot of attorneys would make the trip to D.C. to, maybe go and visit with representatives and explain the needs of what the immigrant community needs. So they're educated with what's happening real time. So hopefully, we have some issues like this EB backlog, kids aging out. I think those are the main factors that a lot of people have been focused on as far as what might resonate with a lot of our viewers.
Okay. So, Lucas, I have one question, about H1b extension. So Donald Trump brought the new policies on H1 extension. Let's say treated as an extension is also new application to verify everything, a specialty occupation, everything. Correct. So the couple of weeks ago, it's ended. Even Biden is revert back to normal. Whatever once, if any H1 is approved previous, maybe less scrutiny or less verification for adjudication H1B extension. In this scenario, earlier we know the USCIS will visit to work location and verify physically. And current with the Biden remove this Donald Trump proclamation or maybe the H1 extension. So is there any chance to USCIS will visit physically at work location?
Well, so we're bringing up a few different topics here. So the first topic we want to discuss is going to be the rescission of the policy that you brought up. And that was something I think we were going to discuss last week on the show. So yeah. It came out pretty much last week officially from USCIS. This is something that I think most people knew was in the works to be rescinded. It just wasn't official until last week. Basically, what you're referencing is in the past, in the officer's field manual, or the adjudicator's field manual, when the officer's reviewing the case, they could just defer and say, okay, whenever they're looking at the case, the petitioner has to meet a certain evidentiary standard. The evidentiary standard, what we use here for H1Bs is going to be a preponderance of the evidence standard, which means we have to show more likely than not that everything is correct or truthful or valid, whatever you want to say. And what this means is more likely than not, or 51% to 49%. So it's a very low evidentiary standard. Now, when we refer to evidentiary standards, we often hear people in criminal trials, like where the judge says, or the jury, we find the defendant guilty beyond a reasonable doubt. That's the highest standard in evidence. So beyond all doubt, we know there's no question that the evidence supports our conclusion. When we talk about, again, H1Bs, it's the same process, but we're looking at where the officer has to say, well, the petitioner submitted these documents and it looks more likely than not this is true or this is valid, then they have to accept it. Now, that helps reduce a lot of the work whenever we're resubmitting similar or the same documents. So if I, for instance, in the past had been determined to have met the specialty occupation requirements by my education and background, then an officer would not have to reanalyze that because that's not going to change, you see. So with that requirement now removed, or, to determine if my master's degree came from an accredited university, right? Or maybe I was approved and I had temporarily attended Farmington University, right? So now these things cannot be reviewed again unless, USCIS determines that there was an error in the original approval, or if there's a gross mistake or error by the officer that made that, or if there was a fraud or some, misrepresentation of fact that the petitioner or someone submitted. Those are the only way that now that USCIS can go back and reopen a case and maybe deny or reevaluate what was submitted earlier. So it's really good news. This will also help speed up processing times. So people who don't want to have to pay the extra $2,500 for premium processing, hopefully we can still, go back to where a case could be approved in, a month to 6 weeks.
Yeah, about H1 extension, recently I observed or I'm seeing, so H1 is approving very fast. It taking, in general, it taking maybe 4 weeks or 5 weeks. USA is adjudicating approved the H1. Let's say after May 17th, if I apply in general without premium process, what do you think will approve? Let's say it will take, if USCIS is reviewing, adjudicating in within 4 weeks, Do you think H4 EAD also adjudicated at the same time, or it will take it will treat it as a two separate application and adjudicated later?
Well, so remember, it should be close to the same time because the cases will not be separated like they were this past couple of years. Now, whenever a biometrics appointment is necessary, that application has to be put aside until we get verification from the biometrics that the person didn't commit a crime, is not some fugitive at large, or some other information is pulled from the biometric results. So there's a report that comes back that allows the officer to go ahead and review everything again. And so by the time you split everything apart, really both cases are on two separate courses at that point. Without the biometric requirement, everything should go back to the way it was, where, we don't have to worry about the H4 applicant being a criminal. We could just go ahead and look, say, oh, they maintain their status. The principal H1B non-immigrant is going to be able to extend their status. Therefore, the H4 dependent can also go ahead and extend their status. Now, in the past, we would see the approvals, within a day or so of each other, if not the same day. We have to always remember that for the cards to be issued, it might take, an extra week, sometimes, depending on the volume that they're printing at that time.
Okay. Yeah. Thank you. It means if the H1 application assigned to the one specific officer, the same officer will verify the both H1 and H4, right? You mean to say?
It should be the same officer, but again, at the same time, if it's not, we're not having any pause or delay waiting. So even right now, let's take, for example, let's say I file an H4 extension request, and if I filed the H4 extension request and I have to wait for biometrics, well, my file is going to be sitting somewhere and no one's going to work on it until the results come back from the biometrics. So that's the delay that's going to be taken away.
Okay. Yeah. Thank you. Lucas, we have a call. Let me take a call, then we can discuss further topic.
Hello.
I think call from Omaha, Nebraska. Yeah. Yeah. Just tell me what your name and yes, please. Hello. You can ask the question to Lucas. Okay. Maybe Ravi, if you have any question, you can ask question to Lucas. Ravi, are you mute? No, I don't think you are not.
Hello, can you hear me?
Hi, Ravi.
Yes. Go ahead. Yeah. Yes, we are hearing. Just go ahead. Yeah, I think some technical problem. We are not hearing properly. Maybe you can post your question in Facebook comments or YouTube comments. We will address. Yeah, or else we can check later after 5 minutes. Yeah. So I think Ravi joined. Ravi, do you have any question? Ravi?
Well, while we're waiting on
yeah. Meanwhile, we can go for next topic. And so you said is prevailing wages policies, right? Is any directly, indirectly impacted to the H1?
No, it shouldn't be impacted directly to H1 unless your employer uses the 9141 form requesting DOL to issue the prevailing wage. I do want to kind of change the subject, if you don't mind, real quick, and pivot. I know right now we have a tremendous problem in India with the coronavirus pandemic, and
Yes.
it's impacted a lot of people. A lot of people I know, a lot of the clients that we help and assist, a lot of them have been touched by this with their, where their family might be going through a hardship or a loss of a relative. And we want to make sure that everyone, obviously you have to be there for your family, and if you have to travel, take the right precautions and protocols, but also be mindful of the travel restrictions or the guidelines that are required for when you do travel. We want to make sure that everyone stays informed, so whenever there is an emergency, there's no delay one way or the other of impacting, how soon you might be able to go back home. So, staying in touch with the Indian consulate to make sure you have notifications on their travel restrictions or guidance on that. Obviously, if you have the opportunity here in the States to have a vaccine, take advantage of that while you can. And then, hopefully everyone stays safe back home and everything, all the numbers go down and everything gets back together. But, be prepared and make sure that you have an idea of the protocols of what to do, such as you're going to have to have a negative test, a PCR test, before you fly within 48 hours. I've had some clients or acquaintances where they've tried to travel with like Air Emirates, and they not being able to board a plane even with the negative test. So make sure you try and get as well educated as you can, just to be prepared if any event arises where you might need that have an emergency.
Yeah. Yes, Lucas, we are discussing about the visas situation in India, and all consulate. The most of the consulates is cancelled all visas. Maybe it's giving only the emergency visas, Delhi, Mumbai, and Kolkata, Chennai, and Hyderabad. So these places is worst and is going. So the USC is saying is that they can allow the emergency cases. What are the emergency? Let's say how we can understand which scenario is become emergency, or can you share a little more so that everyone understand?
So are you regarding to emergency services as far as a non-immigrant visa, or?
Yes, non-immigrant visas.
Well, so what we have to do is we have to make sure that we remember, of all the couple hundred countries that, 250 plus countries that are in the world, each country has its own unique sovereign state. And each sovereign state has its own guidelines as to how they're addressing the coronavirus pandemic. So, if you go to Italy or Hyderabad, you might have certain guidelines that might be different than if you were in Berlin or if you were in Vienna. So there's different guidelines and restrictions. Obviously, the EU has their own guidance between their own members. I think Nepal and Bangladesh right now have pretty much closed the borders with a lot of trade and travel between India and those countries. So you have to remember each place. So when the U.S. Embassy is operating in Chennai, Hyderabad, Delhi, Mumbai, Calcutta, each region is going to have its own policies there, and the U.S. Embassy there is a guest operating in that environment, and they can't operate more than what's permitted by the local governments. So if there's a lockdown or if there's any other issues there that impact the availability of the officers issuing visas, then obviously that's one. Number two, certain visas are still not being issued, especially immigrant visas. That's why we've seen the employment-based numbers move so quickly. I think typically you see in the world on a monthly basis about 200,000 family-based or the GC visas being issued on a month per month. And last month, I think there was a total of 20. And those 20 were issued based upon emergency situations. So it's a very high standard. It's a very much a case-by-case basis. It's very unique to showcase that evidence, what makes it, that an exigent circumstance or an emergency. And, that's really all I can say is it's really the location of where the visa service is going to be is very important, and also the type of visa you're requesting is very important. So if you're going to get stamped with the H1 visa, there's no restriction to that. That policy sunset or was not extended from whenever Donald Trump issued that last year. And moving forward, I don't expect the government to do an overall ban on certain non-immigrant visas again like that, especially with this administration.
Okay. Well, actually, what I'm seeing is most of the H1 holders, maybe they do not have the visas there. If it means not like that, but it getting the emergency situation, they have to travel India. But if they unable to think, it means to think properly and not taking to right decision whether they want to travel or not, because there's a very bad circumstances in US and India. So everyone looking for the emergency visa slots to get back to US and come back to US.
Well, that's very much true. So the availability of the appointments are going to be limited based upon what local government does and how many other people are trying to schedule the appointment, because the consulates are going to only operate at a certain level of people that can come in, and it's very much reduced based upon the pandemic. So I know Lockbox, Dropbox has been expanded quite a bit for people to qualify that normally would not qualify. But even if there is an issue, I've even seen a lot of 221G administrative processing notices being issued. So, we have to, if you have to go, make sure if it's an emergency, it's an emergency, obviously, but make sure you stay in communication with your employer, maybe your attorney, to make sure you're as well prepared as you possibly can be if you need to be stamped or, have travel accommodations or something like that.
Yeah. Thank you, Lucas. We have the 4 calls added into the show. Omaha is the last 3 digit 410. Do you have any questions?
Yes. Yeah.
Yes, please.
This is Pradeep again. Can you hear me?
Praveed? Yes. Your name, please?
Yeah.
Pradeep, yeah. Pradeep, you go ahead.
Yeah, sorry, I joined previously and I couldn't hear you guys, so I had to drop off and then join back. If you remember, again, first of all, thank you both for taking your time to help the community out. And last week I was eagerly waiting for your show, but it didn't. For some reason, I was not able to, get through that. If you remember, right? So 3 weeks back or so, I called you, Lucas, on I-140 issue, wherein the job position was different than the poem. So finally, the attorney prepared.
Yeah, Pradeep, your voice is coming properly. Pradeep, are you hearing our voice? Your voice is not clear. Okay. Let me take another call and we will discuss again with Praveen later. Ravi, do you have any questions? Okay. I think Srinivasa Rao, do you have any question today? Okay. Vinod, are you hearing? Lucas, I think I'm facing one issue. Let me connect back to. Just give me a second.
Sure.
Yeah. Yeah.
From the HR person on this one, explaining, the single support letter as manager. Yeah. So having said that, right? So those things basically does it make sense if we are going in the right?
Pradeep, 1 second. Actually, we saw some issues. So can you explain again your scenario? Sorry for.
Yeah. Yeah. So okay. So so should I start from the beginning again?
Yeah.
Please.
Yeah, we missed quite a bit, so if you don't mind.
Okay. Sorry. Yeah. So what I was requesting was, Lucas, like I talked to you 3 weeks back, and then attorney is ready to file her response early next week, and she prepared the documentation, sent it across. Yeah, I just wanted to get an opinion from you. And I was looking for you last week, but I couldn't join this conference call last week. And the thing is, right, so the way that the attorney is trying to respond to this RFE is saying that though the job position is different, the job responsibilities are exactly the same when compared to what's listed in POM. And the comparison, the way she has done is basically comparing each line by line with what's there in the POM and what's there in the resume, and what I have been doing as part of my current job. And also, as a support to that, she also took a letter from the manager confirming that it's the same job responsibility as what's stated in the POM. So those are the two arguments. Along with that, and that was back in 2017, there was an organizational title changes across the board to level set everything. So she is using that as a support documentation too, along with what I informed earlier. Right, and one thing that I see is missing is, though manager says the bona fide job of rigorous, but there isn't anything from HR, Human Resources Department confirming that. So I'm not sure if, I tried to see if that's possible. There isn't any reply from the, neither from attorney nor the HR department. I'm not sure what's going on there. But I wanted to see.
For the bona fide job offer, I mean, it could just be something that they probably prepare as far as just a statement saying that they want to, that the job offer is still there. And it might not be anything that would involve you or something that you would receive. I don't know if the attorney shared the full response with you, or if it's just they shared it partially, kind of what they wanted to do to address the RFE. But I remember now we discussed a couple of weeks back that this is, I think we just said that, USCIS should not go by the job title, but rather the position itself, the job duties. And that's really what defines what a job role and requirements are. We could call you, engineer, specialist, and then change it to, supervisor, or not super, developer of, whatever. And as long as the job roles and functionality are the same or similar, then that's really the same job. Because as you just explained to us, a lot of companies, especially large companies, they go through organizational changes and hierarchies and everything else about how they, have their positions structured within their organization. And this changes from time to time. Maybe you have a merger and an acquisition, something like this, and the new entity might have a different terminology and things like that. So I think hopefully everything should be addressed. It's kind of I think an excessive reach by USCIS to even go that far to issue the RFE like this. But as far as bona fide job offer goes, that's something your employer would it's a one-page letter that they would submit with the response. It shouldn't be anything for you to be concerned about in that regard.
Yeah, but attorney shared the complete response to me, that document, and then it also lists down the enclosures, what's enclosed as part of the RFE response, and it didn't list anything from HR per se. So it has that organizational change, the documentation, and then letter from my manager, and ETA form 9089, and form I-140, and then the resume. Those are the 5 enclosures that was put together.
Pradeep, if you would like, we could maybe sidebar the discussion to be more of a private discussion. And if you wanted to share the documents, I would be more than happy to look at it, review, and give you my input. I don't want to necessarily guess or speculate about another attorney's work or their work product without knowing everything. So if you want to send me an email or call me tomorrow, I'd be more than happy to discuss that with you and give you, my input.
Yep, sure. That sounds good. I'll do that, Lucas.
All right.
Pradeep, you can send an email info@bgimmlaw.com, or you can call to the 214. What is it? I forgot it.
774-4713.
Oh. Yeah. Thank you.
I'll do that. Thank you.
All right. We'll talk to you tomorrow.
One final question, right?
Uh-huh.
Yeah. So one final question on this one, Lucas. Like, if for some reason, right, this gets denied or something, right, in the worst case scenario, I think we talked about it, but I just wanted to make sure I understand. So, would I be able to file one more 485 again with the same, again with the downgrade, or would they, like in the 485, there would be some questions like if anytime previously if your immigration petition was denied or something, right? Would that impact any future 485s? That's my major concern too, right? So could there be a side effect if something goes wrong?
Well, number one, I would recommend not to dwell on all the negative things that could happen because you might worry about things that at the end of the day won't have any impact on your case whatsoever. That's number one. Number two, there's multiple remedies you have if this is denied. Okay, so don't worry. I mean, one of the remedies, obviously, you could refile. Now, refiling is probably, depending on what your priority date is, it's going to be limited to this upcoming October. But you still have the opportunity to do an MTR, or you could file a lawsuit, with the support of your employer and sue in district court. We have a couple of actions from our office pending right now. And, that's something that a lot of people, just because of such delay and such issues over the past 2 or 3 years with USCIS, under the Administrative Procedures Act, we have, which guides USCIS and other agencies, we have a certain amount of opportunity for judicial review of the record, right? So if there's something that's arbitrary or capricious with the decision and with how it's made by saying, well, this job duty is not exactly matching over here, that's pretty much out of line with what the law says or the regulations guide the officers in that regard. And something like that, depending on what the result of the denial is, we'd have to analyze that. But we could definitely file a lawsuit, alleging an erroneous denial based upon an arbitrary or capricious action by USCIS. So there's a lot of different steps that and actions we have. So don't just think if this happens, it has to be this, or if this happens, it has to be that. First and foremost, we want to make sure the RFE is complete. It addresses everything, because if you do go the path of filing a lawsuit, you are not able to really add more evidence to the record in the future. So you want to make sure all the evidence and everything that you would have to support that lawsuit is included in the RFE, because that would be the entire record that a judge would be reviewing. So, and this is more of something I can discuss with you offline. We can kind of look at the record, and I can give you my input of what would work best. Okay.
Sure. Yep, that's great. Yep.
Thanks.
Thank you, Pradeep.
Yeah, thank you very much.
Yep, thank you.
Ravi, do you have any question today?
Hi. Hello. Hi. Can you hear me?
Yes,
Ravi.
Hi. Yeah, thanks for both of you taking time to answer all these questions. So my question is I know after filing 485 after 180 days, so if we can change the employer, and if we can file 485J to show the job and responsibilities same as. So normally earlier the jobs and responsibilities are where these will mention. They mentioned in the labor or I-140.
So they're going to be mentioned in the ETA, the 9089, or what we call the labor. Okay. Sometimes, this is each attorney is going to have their own way of doing this. I'll have in my letter of support that I file with the I-140s basically a real brief description of what it is, and we want to reference the ETA 9089. We don't want to, have too much of an opportunity for an officer to say that the job duties described in the I-140 don't match what was approved in the labor. So we want to limit that, and we want to make sure everything goes back to that ETA 9089 form. Now, what you can do is you should be able to have a copy of that, and you wouldn't need to do anything with the supplement J at the moment. You can have your a clear conscience after 6 months of a pending adjustment of status, as long as you don't have a downgraded I-140 still pending. After the 6 months, all you have to do is just join a new employer. As long as the job is the same or similar, when it comes time for a final action date on the adjustment of status application, they would request a supplement J at that time. You could, because you might change an employer again before your final action date becomes current. So as long as you follow the guidelines, make sure that the job duties are more or less in the same neighborhood of what was filed with the original application, I think you'll be okay.
So the supplement, 485J supplement, is required after becoming final action date current, or as soon as after changing the employer?
It's whenever your final action date becomes current. That's when USCIS will continue working on your case. So, I think we discussed 2 or 3 weeks ago where people want to go ahead and send in their medicals and match it with their file. And what I always recommend and tell people is the filing date allows you to go ahead and file your adjustment of status application, advanced parole, EAD. The officer's not going to really work on the adjustment of status application until the final action date becomes current. So everything's just going to be sitting in a folder or file until the final action date becomes current. So if it doesn't be, obviously we're seeing historic movement right now for final action dates. So if you take that out of the context we've seen, let's say, 2 or 3 years ago, we know someone with a 2009 EB2 priority date, we would see, maybe someone waiting a year and a half before that final action date becomes current. So a lot can happen between that year and a half, as far as changing employers or positions, right? So I would just wait. It's best practice just to wait until you have a request either at the interview or you receive an RFE prior to the interview.
Oh, okay, got it. So it might be better to, even though if we change the jobs, it might be better to wait until become current, and once we get RFE, then we can respond. Okay, got it.
That's usually what I would recommend, and obviously everyone has their own unique case. So
Okay.
based just as a generic answer, that's what I would say. But if maybe there's other factors that might impact you differently. But
Okay. Okay, but I mean, in sometimes if there is no RFE, then no need. Like if they might be who might get approval directly too, right? There could be a chance.
typically, what you'll get is a notice, an RFE. Before the interview, you could get RFE, or you could just receive a notice saying there's a deficiency. Bring this to your interview with you, along with these items, and you hand it to the officer at that time. So either, I've seen it both ways, but I would wait till it's closer to that time, especially for your final action date's current. Okay.
Okay. And one more final question. Like, what are the chances of rejecting this 485J supplement? Like, is there any any rejection too for that, or?
So there's not much chance of rejection. Now, I do want you to be aware that as of about a year ago, the officer's adjudicator field manual changed the guidelines on, the scrutiny allowed for comparing the roles and responsibilities. So in the past, just by saying the job duties are pretty similar, they don't have to be a perfect match. That would obviously be a red flag if everything was exactly a match. But as long as it's within the same neighborhood, they used to approve. Now, the scrutiny was increased a little bit about a year ago to where the officers are directed to review and look at things in a certain context to make sure that they are matching. But if you work with your attorney and your employer, everything should be fine. The supplement J is just a real basic form, and then the job offer letter accompanies that, and it's usually just a one-pager with one paragraph in it. So there's nothing really too detailed that you would have to worry about.
Oh, okay. Got it. Thank you.
You're most welcome.
Thanks, Ravi. Thanks, Ravi, for calling. Yeah. We have Vinod. Vinod, you can go for next question.
Okay. So can you hear me?
Yes, Vinod.
Yes, Vinod.
Yeah, Lucas had a question. The thing is that these days we applied for H4 EADs, but we didn't get any H4 EADs. We're getting, H4 GC EADs, the one that have Class C09P on it,
Mm-hmm.
And then can we use those? Using the H4 GC EAD, would it switch the primary beneficiaries H1 to EAD status, or it's both two independent things?
Two independent things. So obviously, if you want, you can maintain your non-immigrant status H4, and then also have GC EAD. That's independent of the primary H1B visa holder. So let's say your wife has her EAD. She would not be required to maintain EAD for C26, or that would be the H4 EAD. And that would allow her to work under the CO9, which is better, because if you have to renew it, once you get the EAD, it's only going to be valid for 1 year. But at the same time, it comes with advanced parole, and if it expires before you get the renewal in the mail, you can work on the receipt for up to 6 months. So it allows more flexibility in the sense that once EAD expires, you don't have to stop working, if that makes sense.
Okay.
I hope that
I
helps.
can still be on a valid H1B status. Yeah, I can still be on a valid H1B status and still go. She'll be on an EAD status. That's what you're saying, right? And if something happens, 485 get rejected or something, bad happens, then she can go back out in the country and come back in with a H4 visa stamping, right? That should solve the problem.
I mean, you can still maintain your H4 at the same time you maintain the H1. The EAD is just permission for her to work, and also advanced parole to travel. It doesn't have anything to do about a status per se. So she can still maintain the H4 status with her I-94. That's perfectly fine, and still be able to work with this EAD. That's perfectly fine.
Okay. Even the same with traveling too?
Well,
for example,
so,
I have an H1B stamping and she has a H4 GCEAD with AP and we are traveling together. Then it will not switch my status anyways. So right?
No, it won't affect your status.
Okay, but there were some talks like if I get an EAD and I use that GCEAD, then it will switch me to an EB2, EB3 category that I applied for, and I cannot switch to EB2. There was talks like that, Is there?
So here's the issue: you want to maintain your I-94 with a non-immigrant status to give you the best advantage to maneuver like what you have previously done to file for a downgrade. And if anything were to happen to your adjustment of status application, you don't have to worry about departing the United States or stop working or anything like that, because you have a backup plan, so to speak, with your H1B. So it's always best practice, if you can, especially now that we see the dates moving so quickly. I would just try and maintain the H1B as much as you can. Obviously, when you re-enter the United States, you want to enter with your stamp. So make sure your I-94 is issued and that you can resume your H1B employment. If your wife decides to enter and not enter on H4 for any reason, which I don't know why she would want to do that, unless there's an issue maybe that comes up.
She's not able to
travel.
work because she doesn't have that H4 EAD, because we applied for it and it's taking forever to get it. Whereas we already got the H4 GCAD.
But if she has GCAD, she can still work and still be on H4. That's perfectly fine. It's just employment authorization. So it's not a visa status. It's employment authorization in a advanced parole for travel, which means, if you look at the thing the way it should be designed and created, it's just like H1. The way the system was set up, you come here, you work for an employer for a few years, up to 6. Hopefully within that 6 years, your employer says, you know what, Ravi, you're a great employee. I'm going to sponsor you for your GC. And then before the 6 years are up, you'd be able to just easily go through and get your GC approved. That's the way the system was designed. All these backlogs and these other delays that have come up were really unintended. So the way it's set up is this GCEAD is just something you have for under a year. We're talking historically here, not now, but it's something you would have for a few months, and then you would have your GC in the mail. For family-based cases here, I've actually received the GC before we actually ever get the EAD sometimes. So, it really is something that just allows someone to work and travel until the adjustment application is completed. And, typically we're talking about months, not years. But now, due to this backlog and everything else and this whole mess that we have right now with the H1Bs and EB backlogs, this is the reality we live in, and it's confusing and it's difficult. But going to answer your question, Ravi, your wife's perfectly fine to work on the GCEAD and maintain her H4. That's not a problem. Okay.
Yeah. Thanks, Vinod. No, thank you very much for bringing these questions and scenarios. Yeah. So this question has helped to a lot of people, and is a chance to understand how they can maintain the H4 and GC 485, the EAD. Lucas, I have a couple of questions on this one. Just I'm categorizing H1B and GCEAD and H4 and GCEAD. Let's say, example, I have the H1 for next 3 years. At the same time, I got GCEAD. If I want to use the GCEAD, do I need to leave the country, come back with the advanced payroll, then it will activate a GCEAD on H1, or how does it work? Literally here, I see some gray area, did not understanding properly. It means we don't have the proper information behind activation of GCEAD and H4, H1 and GCEAD.
So if we remember, when we're talking about H1, and we all are, really familiar with this, we have an LCA filed, we have to meet the prevailing wage, we have to, work at the locations listed on the LCA and abide by, the requirements for that visa. If you use the GCEAD, your employer would no longer have you an H1B visa status, correct? And you would not be maintaining your I-94. They'd have to withdraw the H1B. Now you could continue working on GCEAD, but at the end of the day, whenever you go for employment-based, GC to go ahead and move forward, you still have to show that you're making, the salary for the proper position, that the employer has the ability to pay that prevailing wage. So you can't necessarily take a huge pay cut. Number one. Number two, you're still going to have the same position with the same job responsibilities or something that's similar to qualify, because when you get to the finish line for the GC, it's for employment. So you have to make sure that the job still requirements are still there, that the job offer is still there, that the employer still has the ability to pay you, and all these things are easier to prove and maintain if you're maintaining H1B status. It's not to say that you have to, but it makes things much easier if you do maintain that. And I think unless there's just an emergency situation or something that's very unique with the employer, I don't know why it would be so important to worry about stopping one and starting the other. But you have to remember, the employer is also the second part of this equation. So if an employer just decides one day to stop, change your hat from H1B to GC, there's a lot that goes into that. There's a lot of extra attestations that that are required to have as an employer to show that we have the job posting requirements, that we have things like this for the non-immigrant visa that no other American has the ability to fill that position, things like this, which also corresponds to your GC. So there's certain things that are required. If you just stop one and start the other and you don't do it correctly, the employer could face certain fines, if things aren't maintained correctly. It's hard for me to go into specific details, but I can tell you best practice is to go ahead and maintain that H1 as much as possible. And then, use the GCEAD as a backup. Like if you lose your job with employer A and you need to go to employer B, and that employer B is going to sign a supplement J, but something like that, that might be more of an ideal situation. But I would not voluntarily just, stop, because hopefully we get, GCs issued much faster than the rate they've been coming over the past 5 to 10 years.
Okay. There's a good information. Yes, thank you. Lucas, we have a couple of questions from YouTube.
Mm-hmm.
From he's asking about the 485 EB2 and EB3. How to handle multiple I-485 failed in EB2 and EB3 as both are current and final action dates?
So this person has 2 I-140s approved independently, and he has 2 adjustment of status applications pending.
I think the question is not full. The question is, I'm not sure. Maybe one primary and one secondary. Maybe the second one is primary and the first one is the secondary. They applied in EB2 and EB3. Is it possible to apply the multiple 485?
Well, typically, it's possible to file multiple 485s, but typically what you want to do is you're moving one priority date from one category to another. I don't know if you would both have, you could definitely have them both concurrent, but you would have to have independent I-140s for that to happen. At the end of the day, maybe this is the best way to explain it for people to understand. At the end of the day, you have an alien file. You have an alien number. Okay, it's going to be a 9-digit number, and let's imagine that this A number is much like a Social Security. number, right? You're issued one Social Security number. That's what identifies you. That's what identifies me for, taxes, Social Security tax, whatever it might be. Everything with your A file is associated with your A number. Now, you always will have one A number unless you have a false identity that you tell the government that you're also someone else. And that happens to some of our clients who might have come to the country without permission, and they may be given alias or a different name. At the end of the day, the government will use the fingerprints and match up the files. So sometimes we'll have a person with two A numbers with different names, but for the most part, everyone has one A number. You have one file. In this file, you're going to have whatever applications are being processed. So, you're going to have the benefit in this scenario with two different applications, whatever they're both, if the final action date comes faster for EB3 than the EB2 or vice versa, that application would be considered the one that would be moving forward. Once, that application is moving forward and approved, the other application would just be pretty much denied because there's no basis for it to move forward because you've already received that benefit. Does that make sense?
Okay. Maybe they are in a situation, the first they filed in EB2. We know that the EB2 final action date is not moving fast. EB3 is moving very fast. So maybe they are deciding to maybe file again in EB3 for adjudicated for the kids aging out. I think kids are aging out. They want to save the kids. So I think they are deciding to apply in EB3 so that they can get they freeze the kid's age and eventually it will adjudicated for 485. So maybe their question is that they applied the EB2, maybe EB3 is moving forward. Maybe they want to withdraw the EB2 and they want to apply it in EB3, I think.
Depending on how the I-140 was submitted and the underlying facts surrounding the case, I'd have to have more information to give more advice, but I can tell you, for everyone who's listening, just as simple context, when you file anything and you have an alien file, whatever petitions go in that file or adjustments, it's all in one file. Now, the service is going to know what your priority date is. They're going to know what the final action date is and what your visa category is. So based upon that, they'll pull the file and start working on the case when all of these factors match up, if that makes sense.
Yeah, Lakshmi, if still it's not met your answer, maybe you can send an email to info@bgimmlaw.com with details. Lucas will reply with appropriate information for your scenario. So, Lucas, we can take another question from Karan. How do we know 485 has been assigned to or picked up by adjudication officer? Also, can I assume if 485J receipt from USCIS is indicator of something looking into my 485?
So, good question. We've been receiving a few supplement J receipts well after being submitted. Typically, when a file moves, so you'll have the main files, file at the Service Center or the National Benefit Center, and when it's time for the final action dates are getting close or they're current, your file will travel to a field office. And when it travels to a field office, you'll usually receive notification, much like what we've seen. So every time a major step happens, you'll be either given a receipt or some type of notification that something's proceeding with your case. If we knew what your final action date was and your priority date was, we could check the final action date and we could kind of get an idea of where you are in the pipeline. But that's typically what happens. So there is a physical file, and that physical file is arbitrary as it might be, and you might think, "Wow, we live in the 21st century. Why isn't it not all digital? Why do we rely on files?" Well, that's one of the arguments a lot of people have said for immigration reform. We want to, modernize the system where we can have more electronic processing, electronic storage for files. But as of right now, literally, if you have your case going from the National Benefit Center, it's going to go to whatever local field office, and it's going to travel to arrive for that local officer to gather and review your case. So it's a little old-fashioned, but that's the system we have at the moment.
Okay. The second question, same from Karan, just asking about what is the documentary qualified 485 package?
What is
documentarily qualified I-485 package? I think Charlie mentioned in YouTube interview that it would allocate GC visas once documentarily qualified.
Documentarily qualified. So documentarily qualified would refer to the application being complete, that all requirements are there, that there's not anything missing. That's documentarily qualified, that whatever the requirements are for that application, that everything's there and complete. That's what that's referencing.
Okay. So we have another question from Ramesh. There's already we discussed, but again we will discuss about the I-140 downgrade for employees who amended instead of downgraded. Any chance to go back to EB2?
Yes, that's not a problem. So, you have the main thing you have is your priority date, and you have your approved I-140. You're allowed to change visa categories. In this circumstance, for you would go from EB2 to EB3, or EB3 to EB2. At the end of the day, what's important is that labor qualifies to support an EB2. So if you're an EB3, the main issue some people might have is this is a skilled position where we have maybe bachelor's degrees required with 2.5 years of experience. Well, that's not going to meet the requirements for EB2, where you would have to have either a master's degree or a bachelor's degree with 5 years of experience. So, that's one of the key considerations in upgrading, so to speak. But if you started at EB2, you go to EB3, typically you can go right back to EB2. Now, what I would recommend is, again, everyone to stay current with the current events. Make sure that you know where we're at. How is Congress addressing this backlog for these EB visas? What about, maybe the pandemic keeps going? How fast are these visas that are reallocated, moving the visa bulletin dates? These are all things you want to pay attention to and not act too quickly or hastily. Be patient, wait until you're, within a month or two of what the final action date might be before you really make that decision, so you can analyze them and decide what's best for you and your family.
Yeah. So about visa bulletin, it means, I think next couple of months move forward. I think already Charlie Oppenheimer is told next June visa bulletin EB3 will move to the 4 to 5 months or something.
Yep.
It already up to.
So
what about the EB2 will go to only 2 to 3 months, or?
Probably. And what he's does is he's a liaison more or less to try, with the Department of State, and they get an idea of the number of visas that will be reallocated. And what he said, like we visited about a month, 6 weeks ago, is that we're seeing historic movement. So what Charlie's also estimating, which most of the time his estimations are pretty much correct, what they're estimating is, what's going on right now. So obviously the pandemic's not getting better in the world. It's maintaining, if not getting worse. So, there's going to be lots of visas available that are unused that can be reallocated. And we'll still see, historic movement. Like I said, you and I discussed a while back, what if someone qualifies for, the priority date becomes final with the final action date, but maybe they've been stuck back home for the past year. There's a lot of those circumstances too. So the charts and everything that they look at for the I-140s that have been filed and how they use the math to determine what the visas allocated for that, they just know what's been filed and has been approved with that priority date. They don't know who's here to take advantage of that, right? So month by month, they factor in all that information and to see what's available, and that's how they move the dates. So there is a little bit of a conservative nature to moving the dates, because if you move too fast, obviously you'll exceed what's available.
Okay. Lucas, but I have an open question. I think most of the have an open question. We know that October 2020, a lot of people has downgraded EB2 to EB3. The question is, in mathematical calculations, we know that a lot of people has downgraded to EB3. In this scenario, EB2 should go faster than EB3. Why EB3 go fast? And EB2 is behind. It's not moving, just moving couple of months, and EB3 is moving 4 to 5 months.
So there's data that's published by USCIS, right? And we look at the priority date of what was filed for under these visa categories. So if you say India, EB2, in May 2011, X number of cases were filed and approved, right? And we can break it down and see. Now, most of the time, from 2011 to probably 2000, up to, this year, the preference for most people filing is EB2. And so you're going to always see a greater proportion, especially from India, of people who filed an EB2. The only time you really see EB3 for the most part is when people decide, to downgrade or utilize this. So if you can imagine, there's a large group of people, with that priority date in that visa category, and it's really just a lot of people in one line. And there's no benefit to change lines until the filing date becomes current. That's what we saw last year. So it doesn't mean you're going to necessarily get your GC faster. What it means is you're able to put your hat in the ring to go ahead and start the process to help get the EAD, to help get the advanced parole. And what we're hoping, which I think we've been kind of correct in estimating for the past 6 months, is we're hoping for comprehensive immigration reform. We're hoping that kids don't age out. We're hoping that this backlog is addressed and taken care of to where people can move forward with their lives. So I think, all these options we're discussing are all steps to the final solution, so to speak.
Yeah, thank you. Yeah, we are already 19 minutes past 7. So I have a lot of questions, but we can discuss these questions in next session, next Wednesday. So I think I'm ending this show. Do you have anything else you want to share today?
No, I really appreciate everyone participating today. That your questions, your participation is what makes the show work and become a valuable resource for other people in the community. And I encourage everyone to join us again next week at Wednesday at 6 p.m. Central. And if obviously before the show, if you have questions or topics you want to discuss, you can email Venkat, you can email me, or post to our Facebook pages and just say, hey, let's talk about this, or can you discuss this or explain it better? We'd be more than happy to accommodate you. So we appreciate all the participation and look for continued participation in the future.
Yeah, that's really nice. Thank you. Yeah, thanks Pradeep and Ravi, Vinod, Lakshmi, and Karan and Ramesh. So thanks for participation today, and we are requesting and to participate every week, and maybe if you connect to a show and if you give your scenario, that scenario will help to the other non-immigrant. So most of the same similar scenarios will apply for multiple peoples. So just we are requesting to participate every week, every Wednesday, and give your scenarios that will be help to the others. We are trying to improve the show and improve the US immigration topics. Maybe you can send your topic questions or anything on US immigration. Send an email to info@bgimmlaw.com, or you can post in the Facebook, Burgos Law's Facebook and Telugu NRI Radio Facebook. We are open for conference call. Maybe you can connect to the conference call and you can ask the questions. And we are open for wide range. Just we are looking for participation that will help to most of the H1, maybe non-immigrant holders. Yeah, thank you, Lucas. Thank you very much today's show. Bye. Until next week, we will meet the same time and same platform on next Wednesday, 6 p.m. Central Time on immigration show. Thank you very much. Bye bye. Good evening.
Bye.
Thank you. Thank you.